This is the Thom Hartmann Program.
And welcome back. Thom Hartmann here with you. And on the line with us right now is the Chief Justice of the Alabama Supreme Court, Justice Roy Moore. The website, judicial.alabama.gov/supreme.cfm. We'll have a link to that in our on our website. Justice Moore, welcome. Judge Moore, welcome to the program.
Thank you, sir. It's nice to be with you.
What is the correct, is it correct for me to call you Justice or Judge or Chief Justice?
Most people just say Judge Moore.
Okay.
The way they know me, you can call me whatever you want.
Okay, great.
Well, nearly whatever you want.
Okay. Well, thank you for dropping by. In 1814, Thomas Jefferson wrote a letter to his friend Dr. Thomas Cooper about the Ten Commandments, which you're most famous for, although, what I really wanted to talk to you about is this whole gay marriage thing that's going on down there. And in that, he said, and I quote, "Finally, in answer to Fortescue Alon's question why the Ten Commandments should not now be part of the common law of England, we may say they are not because they never were. Christianity was not introduced until the 7th century, the conversion of the first Christian king of the Heptarchy having taken place around the year 598, and that of the last around 688. Here, then, was a space of 200 years, during which time the common law was in existence and Christianity no part of it. We might as well say that the Newtonian system of philosophy is a part of the common law as that the Christian religion is. In truth," Jefferson said, "the alliance between church and state in England has ever made their judges accomplices in the frauds of the clergy and made the judges even bolder than the clergy." Sir, do you feel that you are stepping beyond the range of a judge by asserting divine doctrine on who can and can't get married?
That's a complicated question you asked. You refer back to the common law, and you refer back to, of course, Christianity. Well, let me make a distinction. The common law clearly recognized the Ten Commandments from King Alfred, long before 632, or 832, whatever you said. Back at the
well, it's what Thomas Jefferson said. He said 598 to 686. Those were the years when the Heptarchy, when the kings of England became Christian. The very first one was 598.
Sure. Even before that, King Alfred recognized the Ten Commandments, and separation of church and state was espoused by Thomas Jefferson in his letter to
James Madison,
Danbury Baptist, in January 1st, 1802. Are you familiar with that?
I am, yes.
He said, "Believing with you that religion is a matter between man and his God, I regard with sovereign reverence that act of the whole American people that declared that their legislatures should make no law respecting the establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state."
Right.
But he did not, in so saying, exclude the acknowledgement of God. In that letter of January 1st, 1802, he ended by appealing to God, the God that created us, in that letter.
I could read you 15 other letters from Thomas Jefferson asserting that he was not a Christian, that the founders were not Christians. It does me no injury for my neighbor to say there's 20 gods or no God. It neither picks my pocket or breaks my leg. In his autobiography, he talked about how when he wrote the Virginia Statute for Religious Freedom, an amendment was proposed by inserting the word Jesus Christ, so it should read a departure from the plan of Jesus Christ, the holy author of our religion. The insertion was rejected by a great majority in proof that they meant to comprehend within the mantle of its protection, that is the Virginia Statute, the Jew and the Gentile, the Christian and the Mohammedan, the Hindu and infidel of every denomination. He talks about how George Washington refused to assert Christianity. It's quite clear, which takes us back, and probably it's going to be an unproductive argument between you and me about whether the founders
we could
were
go
Christians.
on and on about this, Tom.
Right.
You want to hear what Joseph Story said in his book published in 1833, who was a justice of the Supreme Court? I'll read to you. He said, "At the time of the adoption of the Constitution and the Amendment to it now in consideration, the general, if not the universal sentiment in America was that Christianity ought to receive encouragement from the state, so far as was not incompatible with the private rights of conscience and the freedom of religious worship. An attempt to level all religions and make it a matter of state policy to hold all in utter indifference would have created universal disapprobation, if not universal indignation. it yet remains a problem to be solved in human affairs, whether any free government can be permanent, where the public worship of God and the support of religion constitute no part of the policy or duty of the state in any assignable shape. Justice Story wrote the commentaries on the Constitution, which are still quoted by the United States Supreme Court.
Right, and James Madison essentially wrote the Constitution, and his first veto in office was vetoing money to go to a church here in Washington, D.C. to provide for to run the poorhouse in D.C. that George Washington had established. It had been run as a purely secular thing up until that point. The Presbyterians wanted to run it. It passed Congress, and James Madison vetoed it, saying that the federal government should not be giving money to any particular religion. He said it would establish a bad precedent. You're surely familiar with that.
And Jefferson, at the end of his letter on January 1st, 1802, said, "I reciprocate your kind prayers for the protection and blessings of the common Father and Creator of man."
Yeah.
None of these excluded God from our Constitution or from our law. You can talk about Christianity as a religion, but basically, Washington went to the Catholic Church, as a matter of fact, immediately upon the beginning of the Constitutional Convention. We could go on and on, Tom.
Yeah, that's my point. It's not going to be productive. What is your argument for asserting that, as the Chief Justice of the Alabama Supreme Court, you can defy a federal judge's ruling?
What's the law?
Well, I believe the Supremacy Clause of the U.S. Constitution is, and Article 3, Section 2 establishes the Supreme Court, the inferior courts, and this judge, actually, there's two steps to it. Number one, this judge said to your AG, your Attorney General, the chief law enforcement officer in your state, this is what you have to do. And then he appealed to the Supreme Court. The Supreme Court said, no, this is what you guys have to do.
So are you assuming that the federal judge that ruled in this case had made a law?
No.
Okay.
No, and in fact, probably you and I agree more than you realize on that. I
don't know if we agree or not, but do we agree that on appeal to the Supreme Court, the merits of the case did not proceed to the Supreme Court?
Not yet.
No. What they ruled on was an injunction, which bound only the Attorney General in the case. There was no probate judge in that case, no probate court in that case. My ruling put out that they were still bound by the Alabama Constitution.
No, but the Attorney General is the chief law enforcement officer of the state. He's the representative of the state. So if the Supreme Court is addressing the Alabama judiciary, they're doing it through the AG.
The Supreme Court did not address the merits of the case. They addressed the injunction on the Attorney General. That's far different. Furthermore, what is the law? The law is not what a federal judge says it is. And if a federal judge issues an opinion, you know that under our law, it's not binding on state courts.
Well, I know that's what, well, actually, you could argue that it's not binding, period. I mean, look what Andrew Jackson did with the Trail of Tears decision.
It's not right. It's not binding, period, except on the parties before the court.
Right.
And that's under Rule 65 of the Federal Rules of Procedure.
Right.
In other words, what this court did was, in trying to enforce her order on the other probate courts, I don't think that she even tried. I think the plaintiffs asserted that she tried. She knew better. She couldn't enforce her order against any probate court because they were not under authority. But in our federal system, a state trial court's interpretation of federal law is no less authoritative.
Judge Moore, we've got a very brief break coming up. Can you stick around for a little bit?
Sure.
I would like to extend this conversation, and I'd like to share with you some conversations that Phyllis Schlafly and I have been kicking around for years.
Sure.
We'll be back with the Chief Justice of the Alabama Supreme Court, Roy Moore, right after this.
This is the Thom Hartmann Program.
We'll be back with Judge Moore in just a moment. So, Judge Moore, you're still with us?
Yes, sir.
Okay, great. So the conversation that Phyllis Schlafly and I have been having for a number of years, and she wrote a book about this, and I wrote a book about some stuff that is adjacent to this, I suppose, arguably, is this whole idea of judicial review and judicial supremacy. And I'm curious your take on it. Phyllis Schlafly's take, and my take, frankly, is that Marbury v. Madison was wrongly decided, or arguably was correctly decided but wrongly interpreted.
I think that's where I would stand. And
that the court has the power to be the final appeals court in any matter of law or fact, but that they cannot write law. That Roe v. Wade was wrongly decided, that Plessy was wrongly decided, that Dred Scott was wrongly decided, that Brown v. Board arguably was wrongly decided. Because in each one of these cases, you had the Supreme Court stepping out and saying, we're essentially create law. I think Roe v. Wade was probably the most egregious. Is that your understanding or your perspective on the Supreme Court?
Well, definitely no judge or no court can make law, period.
Right.
That's not what we say. They make the law of the case, or a ruling applies to the case before them. But you're talking about what is the supreme law of the land, and that's contained in Article 6 of the Constitution. I think that when Justice Marshall said it's our duty to say what the law is, people think that he could say what the law is.
Right.
And that's been interpreted that he can make the law. He's not saying that. He's saying by our interpretation of what the law means.
Right, yeah, exactly. It was in 1803 in the Marbury case, and in which he said that. So how do we snatch back, and then after that, I'd like to get back to talking about gay marriage in Alabama. But how do we have this precedent that arguably goes back to 1803 in a really big way? I mean, that was the first judicial supremacy, judicial review decision, Marbury. The second was Dred Scott. So not a whole lot was going on in terms of the Supreme Court making law during the first 70 years of this country's history. But they're doing it with almost every decision now.
Yeah, exactly. About every decision.
So how do we take that back?
Understanding of the Constitution, I think.
It seems to me that we have ceased to become a constitutionally limited representative democratic republic, and we have become a constitutional monarchy with 9 monarchs sitting on the Supreme Court.
I agree. And I think that's what we'll talk about in this section on the same-sex marriage.
Yeah. It's which then raises the question: what can Americans do about this? The fact that we now have judges running our country, all due respect, rather than legislators.
I perfectly agree with you, and you can talk to me as a judge, or you can talk to me as a person. Judges shouldn't be running the country, and that's what I'm attempting to stop here. 21 states have bowed down to unlawful federal authority, and I can explain it.
Okay. Go for it. Well, hang on just a second. Yeah. Judge Moore, we have to do another one of these little bumps here, and so we'll be back in about 15, 20 seconds, if you can stick around.
Yeah.
Hang on just a minute. We'll be right back with Judge Moore. Welcome back. 20 minutes past the hour. Thom Hartmann here with you. Judge Roy Moore, Chief Justice of the Alabama Supreme Court, on the line with us. We were just talking about how Marbury and all these cases where the Supreme Court has asserted the authority to basically create law or strike down laws. Apparently, Judge Moore and I are in agreement that the court has exceeded its authority for a long, long time. Is that an appropriate way to say that, Judge? I
would say that's correct, Tom, and I'd say that this case is about an attempt to stop that. And even though some people think I'm ruling out of my religious beliefs or in just open defiance of the federal courts or the Constitution, I'm not. I'm keeping in line with the Constitution.
Yeah.
Basically, what people don't understand about what federal courts are doing is if you look in the last few years, 21 states has succumbed to a federal court's ruling which is not binding on their own courts. In other words, if their own courts interpreted a situation otherwise with their constitutional amendment, that conflict must go to the United States Supreme Court, but we haven't had that.
Right.
The only conflict that's going to the United States Supreme Court is a dispute between two federal courts of appeal. And I think that's a travesty. I think it's a lack of understanding of the law. It's a lack of understanding of what the Constitution was meant to be. In our federal system, the state court's trial interpretation is no less authoritative than that of the federal court of appeals in whose circuit that trial court is situated. That was Clarence Thomas in 1993 in Lockhart versus Fretwell. Mm-hmm. A little bit before that, in 1974, Chief Justice William Rehnquist said, although the state court would not be compelled to follow the federal holding, the opinion might, of course, be viewed as highly persuasive. Throughout the jurisdiction or the cases before Supreme Court, federal courts of appeal, or even Supreme Courts of the states, there's one rule that has been consistent, is that a federal trial court's opinion on a federal constitution is not binding on a state trial court's interpretation of that. And that goes back to the supremacy clause. When people want to know, for example, the other day, Barack Obama said about my case, addressing me, he said, well, everybody knows that federal law trumps state law. So I was asked about this on one of the programs, Fox News, I think it was. And I said, well, the president is correct. Federal law does trump state law, but that doesn't mean a federal court opinion trumps a state court's opinion. Right. We've got to go back to the law as stated in the Constitution under Article 6.
So your argument here is, if I understand this correctly, is that even though a federal court has said to your attorney general, you must allow gay people to get married in Alabama, and even though the Supreme Court has said we're not going to stay that, we're going to allow that order to be kept in place until we do rule on this, and it's expected that they're going to be hearing this in the next 6 months, that you're not recognizing the authority of that federal court to regulate state courts.
No,
but it's not state courts that marry people. It is like, magistrates and justices of the peace, and it's certainly not state courts that hand out marriage certificates. These are people who are employees of the state, and so if the federal judge says to the chief law enforcement officer of the state, your functionaries, your employees here have to do this, why don't they have to do it? I get it where a judge like you could say, no, I'm going to ignore your ruling, and I'm not going to perform a gay marriage. But how does that apply to somebody who's not a judge?
Well, let's go back, Tom, and look at the case of Searcy that was before the federal court, which he uttered that. That's the case where the injunction was issued to the Attorney General, and that's the injunction that went to the United States Supreme Court. Let's look at that case just for a moment. Do you know where that case began?
I do not.
It began in a probate court in Mobile County when they didn't allow an adoption from out-of-state people who had been married in another state. I think it was California.
Okay.
That case went to the Alabama Court of Appeals. And when Alabama Court of Appeals undertook that, they analyzed Section 3603 of the Alabama Constitution and said, we don't recognize same-sex marriage in this case by the amendment to our Constitution, and your adoption is denied. Their next step was to go to the Alabama Supreme Court, but they didn't do that. Mm-hmm. They foreclosed any approach to certiorari before our court and went to the federal district court in the Southern District. Now, that's a direct violation of the Rooker-Feldman doctrine, which prevents an appeal to the federal court. In fact, in her decision, Callie Grenade, who was the federal judge, said this, and I quote, the probate court's decision was appealed to the Supreme Court of Alabama, which assigned the matter to the Court of Civil Appeals. That court affirmed the probate court. Thus, plaintiffs contend they have exhausted all avenues of legal recourse in Alabama, state court, and left without the remedy they seek the adoption. Mm. Well, everyone knows that adoptions don't go before federal courts. Right. But they did in this case, and that's on appeal to the 11th Circuit.
Because they're asserting it's a civil rights issue.
Sitting on the merits of that case.
But
what I'm saying
No, hang on just a second. They're asserting that this is a civil rights and equal protection issue, are they not?
Do what now?
Are they not asserting that gay marriage in Alabama is a civil rights and equal protection issue?
That's what they're arguing. It's on appeal to the 11th Circuit. It's on appeal. Right. It hasn't been decided by the United States Supreme Court.
So if this, we have just a minute. We have just a minute left, Judge.
The Alabama Constitution.
If the Supreme Court rules that gay marriage is constitutional, what will you do?
That's another question, isn't it? We're back on the fact that the United States Supreme Court has not ruled on this issue. Therefore, the Alabama Constitution is as viable today as it ever was.
Right.
That's illustrated by a Florida court in 1997. They stated something that I'm trying to say to you to teach people what this system is about. They said in a system, now this is Florida, where the decisions of lower federal courts in Florida are not binding on the state courts, as in Alabama, there may very well be occasions where the federal courts hold one way while the state courts hold the contrary. That is, after all, a consequence of our system of dual sovereignty.
Right. Federalism.
Is simple. The United States Supreme Court can eliminate the conflict by simply taking up an appropriate case for review.
Okay.
That is the constitutional system.
You got it. Judge Moore, we're out of time.
Hang on just a second, please. Thom Hartmann Program. Call 202-536-2370.
Chief Justice Roy Moore of Alabama, thank you, sir, for being with us today.
Oh, you're welcome, Tom.
Great talking with you. We'll be back.